Good afternoon. My name is Crystal Dahl, and I am the Online Communications Specialist here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Avoiding Common Mistakes Companies Make When Operating Business Aircraft. I have the pleasure of introducing today's speaker, Greg Ripple. Greg is the chair of the Aviation Law Practice Group at Miller Johnson, Meritas' member in Grand Rapids, Michigan. He assists clients on a wide range of aviation-related issues, including compliance with the federal air regulations and representing clients in investigations and proceedings involving both the Federal Aviation Administration and the National Transportation Safety Board. He also assists clients in aviation business transactions, including the sale, purchase, and leasing of get started, I would like to quickly go over a few housekeeping items. Meritas now offers the ability to hear the audio through your speakers. If at any time you have any difficulty hearing this presentation, you may call into the associated telephone line instead. I can send that line number to you via the chat feature. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. If you have any questions, you are welcome to ask via the chat feature found on the left-hand side of your screen. Greg will answer all questions at the end of his presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as Greg's contact details. With that, Greg, are you ready to get started?
Certainly am. Good afternoon, everyone, and welcome to this webinar. I'm glad you could join us this afternoon. And as I suppose you all know, as the title of the presentation, we're going to be talking today about common mistakes we see and companies make when operating business aircraft, primarily from the legal side of things. Business aircraft are not only highly regulated, or business aviation activities are not only highly regulated, but they're regulated by different agencies with different regulatory agendas, and that adds to the complexity of an already complex body. For instance, the FAA has a certain set of rules pertaining to aviation activities. The Internal Revenue Service has their own set. And they simply have different agendas, and sometimes they contradict each other. So what we think complies with the IRS regulations may in fact comply with the IRS, but doesn't comply with the FAA's regulations or vice versa. So business aircraft operators have to structure their operations to comply with these requirements, and that requires a great deal of balancing and knowledge of the regulatory environment, and sometimes a very counterintuitive, as we'll see, regulatory environment. And for lawyers, I think it's particularly difficult because oftentimes these mistakes that we will talk about today aren't noticed by the FAA or by the IRS at first. We could have structures or operations or systems in place for months or perhaps years before the FAA or the IRS or another agency raises an issue. And by that time, not only has liability been established, which makes it very difficult to avoid fines and other regulatory remedies, but it also, frankly, if the lawyers are responsible for establishing the system or the policy or the corporate structure that the FAA or the IRS questions, it can raise some serious issues for the lawyers that were involved in the transaction and the advice they gave that their clients were relying on. So I think the easiest way to do this as we begin is, to deal with, what a scenario, and we'll build on this as the hour goes on. And I think this is all from very common. This very first part, in fact, I've already dealt with this week once, and it's only Tuesday, and I dealt with it twice last week. President of BigCo, one of your firm's clients, or if you're in-house, your boss, gives you a call and says he's decided that the company needs to purchase a business jet. And for our purposes today, let's make it, a Cessna Citation, maybe a CJ2, but it really could be any business jet. And for most of what we talk about today, it doesn't need to be a jet, but let's make it a jet. Those are shiny and fast, and people like them. And he tells you that BigCo is going to use the aircraft to transport employees between the company's facilities, operates in multiple states. He and his executive team want to be able to more quickly reach these facilities, some of which are not in major metropolitan areas, with easy access to airline services. He's sick of having to take his shoes off at TSA, and this is just going to be easier. And besides, if something goes wrong and we have to get an engineer or maintenance technicians to a plant to fix something, the plane will be available. And the company's going to do a decent amount of entertainment of clients, and the aircraft is going to allow them to do that much more conveniently and with a great deal of style, he says. BigCo also has a wholly owned subsidiary, a Little Co. LLC, of which it's the sole member, and it too will use the aircraft, and it's simply going to, in conjunction with its flight services as well. So the reason the president's called you is he's decided he's going to buy the airplane, and he wants you to create PlaneCo LLC. The president explains, he's worried about liability. This is a major asset that he's purchasing. It's millions of dollars, and he's worried about shielding the assets of BigCo from any liability associated with the operation of the aircraft. And because you've advised him before on liability shields, he knows how important it is to take riskier large assets and shelter them in their own single entity, single purpose LLCs. So that's what he wants to do with PlaneCo. BigCo will be the sole member of PlaneCo. PlaneCo will purchase the aircraft and register the aircraft with the FAA. PlaneCo will employ the pilots and will be responsible for the operation of the aircraft. That's all going to take money, of course, and PlaneCo will be funded from BigCo. BigCo will make all the necessary capital contributions to PlaneCo to purchase and operate the aircraft. And then Little Co, for its use, will reimburse BigCo for their use of the aircraft. Seems to be a pretty routine transaction, single member LLC. What could possibly be wrong with that? Well, mistake number one, the flight department company. The structure that we've just described actually violates the federal aviation regulations, the FARs. It creates a flight department company. PlaneCo has been created for the sole purpose of providing air transportation to a parent corporation and its subsidiaries, and perhaps its officers, as we'll see in a little bit, for compensation. And we'll get to that for compensation in a second. So PlaneCo's operations actually require it to comply with the federal aviation regulations to obtain an air charter certificate. This, to a general corporate lawyer, to a general business executive, seems to make no sense whatsoever. But you have to understand the regulations and the FAA's worldview when it comes to business aviation or any real type of aviation. And the FAA's worldview is black and white. We have really two different types of aviation operations. We have non-commercial operations, private carriage, if you will, and we have commercial operations. They're different and they're distinct and they have their own rules. Most commercial business aviation operates under what we call Part 91 of the FARs. There's no real FAA certification. There's no FAA certification or licensing requirements. And frankly, there are less restrictive operational requirements. Part 91 applies to all non-commercial operations for the most part. There are some exceptions we don't need to get into today. But for the most part, 91 governs all non-commercial flight operations, whether it's me on a weekend up in a Cessna 172 sightseeing over Lake Michigan, or whether or not it's Big Co operating its brand new Cessna Citation jet. As long as it's a non-commercial operation, both are going to fall under Part 91 of the FARs. On the other hand, commercial business aviation has to operate under Part 135. Part 135 requires an air charter certificate. It has much stricter operational requirements. The airports that you can operate commercial flights into it are significantly more limited. They're limited by the type of weather reporting information available at the airport. The length of the runway, for instance, has to be of a certain length depending on the aircraft you operate, and its certified specifications and conditions. All of which have to be complied with. And you also have a federal tax on commercial operations. So commercial business operation is far more restrictive than really a very lenient and easy to work Part 91. And so most operators want to operate under Part 91. Gives them a great deal more flexibility, and after all, for the most part, that's why people operate business aircraft, for the flexibility that, frankly, either charter operations or the regularly scheduled airlines can't provide. So why is Planeco a commercial operator? Like I said before, how do they get there? Because at first glance, they don't seem to be. They're just simply providing transportation to a related company. Well, the FAA defines a commercial operator in FAR 1.1 very broadly. It's a person, including a corporation or a company, who, for compensation or hire, engages in the carriage by aircraft in air commerce of persons or property. And again, I can hear some of you saying out loud, well, there's no compensation here. Big Co isn't going to buy a ticket. They're not going to charter. Planeco is not going to hold themselves out to the general public as being able to fly people. There's simply going to be capital contributions as necessary to both purchase the aircraft and operate it. Well, the FAA has defined compensation as very broadly. It can include reimbursement of flight costs, reimbursement of operational costs. It can include capital contributions, such as the case we have here. It can include goodwill or exchange of services. Compensation really is anything of value that changes hands. And lest you just simply take my word for it, the FAA Chief Counsel issued an opinion letter back in 2007 that addressed this point squarely. That, quote, a company whose sole purpose is transportation by air and receives amount paid by a parent company needed to pay the cost of owning and operating the aircraft must obtain certification. That's certification under Part 135 as an air charter operator. So the FAA takes the position that a company like Planeco needs to obtain an air charter certificate if it's going to provide the type of transportation or services that the president of BidCo is asked or intends to have PlaneCo do. Now, oftentimes when I explain this to someone, they bring me in and we explain this, I get a callback saying, but isn't there an exception, Greg? Isn't there an exception for affiliated companies? And generally, I think what they're referring to is this, which comes up pretty quickly if you do a Google search for affiliated companies or flight department companies. And that's FAR 91501B5, which provides that the carriage of officials, et cetera, of a company on an aircraft operated by that company or a subsidiary of that parent, when the carriage is within the scope of or incidental to the business of the company, and no charge is made for the carriage in excess of the cost of owning, operating, and maintaining the aircraft, is permissible. And again, at first glance, that seems to save PlaneCo. We have PlaneCo is another wholly owned subsidiary of BidCo, and therefore it can provide carriage of the officials, employees, guests, and property of BidCo, as long as we don't exceed the cost of owning, operating, and maintaining the aircraft. Well, unfortunately, this isn't going to save PlaneCo, and the reason it's not going to save PlaneCo is the key words here. Other than transportation by air. Because PlaneCo has no other business except to provide transportation by air. Therefore, there is nothing within the scope of or incidental to the business of PlaneCo. PlaneCo exists for only one reason whatsoever, and that is to provide transportation by air, and therefore it can't rely on this exception in 501b2 to provide transportation to BidCo or to LittleCo in exchange for capital contributions. It's simply a system that's not allowed. So going back to our scenario, we explain this to the president. The president takes the advice and listens and seems to take it all in and understand it, hangs up, calls you back the next day, and says, listen, I was out playing golf at the country club yesterday, and I was playing with 3 guys, and they all have planes. And they say, listen, your lawyer's full of hot air. This is the way we all do it. There are 5 or 6 companies down on the airfield, and we all operate with single-purpose LLCs that own the aircraft and operate it. So your lawyer's being hyper-technical. Everybody does it this way. And that's mistake number 2. But everybody does it this way. This doesn't, for those of us with teenagers, this does not get them out of trouble on a Friday night. But mom and dad, everybody was doing it. Everybody is skipping school this Friday. Everybody is going to the party. That defense doesn't work for them. And unfortunately, I've yet to run into a federal or state agency or court that accepts the "but everybody does it this way" defense either. Like I said, it's very common. I guarantee you can go out to almost any business field, aviation airfield in the country and find people operating with the wrong structure, but that doesn't make it right. It makes it wrong. It still violates the FARs. And that's something we need to be worried about. So, I mean, why care? I mean, if everybody else is doing it this way, why should we care? One, a flight department company violates the federal aviation regulations. And I have found that most companies like to be in compliance with the law. I think for attorneys advising clients, it is particularly problematic to advise clients to set up a structure that we know violates the administrative regulations of the federal agency that has been delegated authority over this area. It's very uncomfortable to say, I think you should do it this way, even though it violates the laws. I think our malpractice carriers, frankly, would have a problem with it. So the number one reason to avoid the flight department company, it simply violates the laws, and we shouldn't do that. There are reasons behind why the FAA has this regulatory environment, and we can get into that later if there are questions about it. That's a whole other presentation. So there are reasons to follow it. Two, a flight department company may violate the, quote, compliance with laws, unquote, covenants and loan agreements or insurance policies. In all that fine print on your loan agreement to buy your shiny new business jet for $10 to $30 million, or your used one for $1 to $15 million. Has the bank put in some language that requires you to operate the aircraft in compliance with all applicable laws and regulations? And the failure to do so can get the note called immediately. Or more importantly, do you have an insurance policy that has that as a provision? Does your insurance policy have an exclusion that says that flights operated improperly under Part 135 or parts that were operated under Part 91 that should have been Part 135 flights are excluded from coverage? That could have serious repercussions in the event that we had an incident, an accident, which we hope we never have, but we don't want to find out later that our $100 million worth of liability insurance is actually zero. There have been several cases where companies have sold non-commercial aviation insurance policies to operators who then operated and suffered a loss in a commercial operation where coverage was denied. That's a worst-case scenario and something that would keep us up at night if we had advised the clients that it was okay to go ahead and establish a flight department company. The FAA may also fine the operator per flight up to $11,000 per flight. Now, that's a worst-case scenario, but that's still a significant fine. The pilots that operate these flights, the pilots are also on the hook. If we have flights that were improperly operated under Part 91, may result in the FAA revoking their pilot certificates, their ability to fly. And that would be, of course, that's their meal ticket, how they feed their families, how they keep a roof over their head. It's their livelihood. And it's wrong, at least in my opinion, to gamble with their livelihood by knowingly creating a structure that the FAA would deem illegal. And then finally, and these are just 5 examples, I'm sure we could come up with many more, as I mentioned before, there is a transportation excise tax on commercial flights. And so it's at least theoretically possible that the IRS could come in and seek those contributions on the capital contributions made by Big Co to fund Plain Co and keep it operated. And if you can think of what those contributions may be, that 7.5% excise tax could get to be a very large number very quickly. And again, the problem with these are that when the client gives you the "but everybody does it this way" speech, it's probably possible to get away with it. People get away with it every day. I'll admit that. But when does this come to light? Well, it generally comes to light after an accident. We've all probably dealt with insurance companies, and we know that insurance companies will look at the exclusions to your policy. They will analyze, especially if it's a major loss, whether or not there's a way that they can either reduce the insurance liability, the insurance payout, or exclude it and deny coverage altogether. And that's an awful uncomfortable conversation to have. We've had an accident. We have had not only lost the airplane, but we've perhaps lost high-ranking individuals in the company. We may have lost powerful, high-value, high-net worth guests that were on the aircraft. We may have caused damage on the ground. And all of a sudden, instead of worrying what we should be worrying about, which is the people that were on board and their lives, and frankly, all the paperwork that comes with an incident like that and the legal issues, now all of a sudden we're worried about whether or not when the insurance company and the FAA come poking around to conduct their investigations, whether or not we all of a sudden will have additional legal liability that will create a really large mess for us. The easiest way to avoid that is to set up your company properly to begin with. There are solutions to the flight department company. We deal with them. I think aviation lawyers probably deal with them on a weekly basis. So there are ways around this and setting up the correct structure. It is possible to legally operate under Part 135. If the president of Big Co has the desire and a lot of money and a little bit of time, by a little bit, I mean a lot of time, they can try and obtain a Part 135 air charter certificate. This is a lengthy process. It's a highly technical process, and not very many companies that operate a business jet for their own personal use go to this step, but it is possible. It's also, and we'll talk about this a little bit more in just a few minutes, it's also possible to find an existing Part 135 certificate holder to operate and manage the aircraft under Part 135. Now, this is a more expensive option because companies don't do that for free. And it's going to be more restrictive than operating under Part 91. As we mentioned briefly before, operating under Part 135 has some operational restrictions. It's going to have the tax on the federal excise tax on commercial travel. So it's a more expensive and more restrictive option, but it's in compliance with the rules. Now, perhaps the easiest option is the one the president doesn't want to do, and that is to have Big Co, or perhaps Little Co, depending on what Little Co does and how we set up the transaction, but to have Little Co own and operate the aircraft. There, of course, we don't provide the necessary liability, the desired liability shield. Though, frankly, I sometimes wonder whether the single-member, single-purpose LLC really provides the liability shield that the presidents of Big Co and others thinks it does. But that's an operation. There'd be nothing wrong with Big Co owning and operating the aircraft. That's in full compliance with the FARs. There may be a way to transfer business to Plane Co. So Plane Co has some other business other than providing transportation by air. Now, clients often jump to this. Well, we'll just put some business. I've got some real estate holdings, some real estate management, and we're going to go ahead and put that into Plane Co as well. So although Big Co manufactures widgets, at least Plane Co will have some other business. Well, remember the flights that fall under the affiliated company exception that we talked about have to be within the scope or incidental to the business of the company providing the flight. So we have to be very careful with what business we put over into Plane Co for this to work. It is not simply a matter of giving them something else and then saying, look, they have other business, so the exception applies. Not that simple. It takes some analysis and some strategic thinking to make that work. But there are exceptions. So if you have a client or you work for a company that just doesn't want to operate this aircraft on its own, doesn't want to put the plane into Planeco itself, into BigGo itself, I really do recommend that you talk with somebody that deals with FARs and these types of issues routinely, because there are some creative solutions here. We'll talk about a few later that really can get us around this. But the important takeaway, and really with mistakes 1 and 2, is we don't want to set up these flight department companies. It is the single most common mistake we see. Like I said, I think almost on a weekly basis, I either am asked about it or I see it when discussing a client's operations or a prospective client's operations. It's that common. But here you've got a great client or boss if you're in-house, and the president of BigCo agrees, finally, after a little bit of convincing, that the aircraft will be registered by BigCo. So BigCo will own the aircraft. It will register it under its name. But the president still doesn't want BigCo to operate the aircraft. Again, worried about that liability. We're not in the aircraft business, he tells you. We're not an airline. We make widgets. We're a manufacturing company. So I went down to the country club, and lo and behold, I've got a co-member who owns a charter company, a 135 charter company down at the airport, and he says that he can manage the aircraft and operate it for BigCo. So although the aircraft will be under BigCo's name with the FAA, it's going to be managed and operated by this Part 135 charter company. And, quote, that way all the risk will be on them, period, end quote. And that leads us to mistake number 3, not understanding operational control. Operational control, again, FAR 1.1, which is the definition section, means the exercise of authority over initiating, conducting, or terminating a flight. Exercise of authority is really the crucial part of that definition, and that is defined also in 1.1 as the to use, cause to use, or authorize to use the aircraft for the purpose of air navigation. So basically, it's the go, no-go decision. Who gets to use the aircraft? Is the aircraft going to fly? The aircraft going to make it to its destination? All those decisions go into operational control. The operator of the aircraft is accountable, because it has operational control, for safety and all other aspects of the aircraft operation. So it must have, according to the FAA, a full knowledge of flight operations. It must know that the plane is maintained in an airworthy condition, that the flight crew are qualified to operate the aircraft, not only in general requirements, but also in the daily ones about whether they're qualified to take that flight. They must know the passengers. A lot of people tell me, a lot of clients say, generally it's a general counsel, the client calls and says, well, the executives don't want us to know who's exactly on board. They're carrying a lot of guests, and they don't want us to know who's on board, which always raises a lot of red flags, not only for me, but also for the FAA and the IRS. Because if you have operational control, you need to know the identity of your passengers. The flight crew, on the operator's behalf, must determine whether or not the flight can be conducted safely and in accordance with regulations with the FARs. And very important, by contract or other agreement, operational control cannot be transferred to a management company or to a third party. It always remains in the operator's hands. So, while the FAA is very clear on this. The 91 operator, the company, Big Co, may outsource aircraft management to a third party. And that management company may provide crew members and conduct maintenance and arrange for flight plan and services and provide all the services necessary to operate the aircraft. The owner retains operational control of the aircraft. And generally speaking, when you read these management agreements that the charter companies will provide you, it will state very clearly that where flights operated for the owner of the aircraft, those flights will be operated under Part 91, and the owner acknowledges that it will be in operational control of the aircraft during those flights. So this arrangement that the president of Big Co has come up with has not satisfied, will not do what he wants it to do. It will not remove operational control or the legal risk from Big Co and place it squarely on the management company. That risk, again, remains at all times with the operator of the aircraft, Big Co. This actually, can be a very complicated relationship. And it's one that really all parties have to understand going into. Many Part 91 operators rely on the crew provided by the management company, and this could be, I guess, mistake 3A, is not understanding or not having a crew that doesn't understand who's in operational control. Oftentimes, the management company will provide the crew. The FAA has been for years very suspicious of this relationship. If the management company provides the crew, provides the pilots, but the owner of the aircraft has operational control of the flight, do the pilots of that flight know who's in charge? Is it the management company that, frankly, sends the paychecks every 2 weeks? Or is it the owner of the aircraft for flights operated under Part 91? The FAA has acquired in recent years, therefore, a separate agreement in place with the crew members, crew member agency agreements, that if the pilots are employees of the management company, there must be an agreement in place with the crew members that acknowledges that the owner of the aircraft has operational control of the aircraft and not the management company. Again, this is overlooked frequently. It used to be overlooked, frankly, all the time. I think it's much more common now for these agreements to exist. But it's something on your checklist that you should have. If you have aircraft that are on Part 135 certificates and managed by charter aircraft, do we have crew agency agreements in place with the crews that specify who has operational control when the company operates the flight? The management company may also provide for maintenance services for the aircraft, but that doesn't provide really a liability shield. It just simply provides another company to sue if there's an accident. It doesn't shield Big Co. Big Co, again, is the operator of the aircraft on its flights, always maintains the ultimate responsibility and accountability for determining airworthiness prior to each flight. And you can put all the indemnification provisions in those agreements that you will between the owner of the aircraft and the management company. If there is an incident, everybody's getting sued, and the plaintiff's attorney will tell you you and the management company's attorney to sort out who's going to write the check, but that somebody's going to write it. So the shield just isn't there. So not understanding operational control, common mistake 3 when it comes to operating business aviation. Number 4 is not understanding personal use and reimbursement rules. And again, we don't have a ton of time to get into all of this because, frankly, that would be a webinar unto itself in many ways. It may be several webinars. But Big Co, after he buys the aircraft, the president of Big Co calls and says, I've decided that it would be really nice to use the aircraft, take it down to the lake on the weekends. It's a lot faster than driving. Delta always loses my bags and my golf clubs. It'd be nice just to take the company jet. And during the winter, of course, we're going to want to go out to Vail, to the lodge. And, my kids have scattered with grandkids from, Maine to Albuquerque. And, boy, this plane will let me, go for weekend trips to all those places. And the more he begins to describe all the fun things he wants to do with this aircraft, you begin to suspect that this personal use may actually become the primary use of the aircraft. And that's especially true of very small or smaller, closely held companies, family companies, where the owner of the aircraft and his or her family are synonymous with the company. And what is the company's is theirs. And there are many times we, towards the end of a tax year, begin to look at business use of an aircraft and find that the business is really personal use for the executive and his family. In larger companies, especially publicly traded companies, I think this is less common, but or becomes less common that we have that worry. But it's always a worry I have when, especially if it's their first airplane, a closely held family company decides they need an airplane, especially if I know that there's already a summer home or a lake place or a ski chateau they like to go visit. We have to make sure that they understand the personal use of the aircraft rules. And here the FAA actually is not the problem. The FAA doesn't have a problem with personal use of a company's aircraft by executives. Not at all. But the IRS does. Personal or entertainment use of the aircraft may have potentially large tax consequences for Big Co. The disallowance of expenses associated with the aircraft, changes in depreciation, can all occur dependent on the amount of non-business use that airplane is used for during a tax year. And it's important to do this in advance. Everybody's got to know the rules, especially the bookkeepers at the company, because you can't unfly flights. You get to the end of the year and you found out that you've used the aircraft, 60% for business use, for personal use, and 40% for business use. There may be problems that just can't be fixed for that tax year. So, consultation with an aviation experienced accountant is a must. This can either be there are numerous accounting firms that specialize in business aviation and have the expertise. That's all they do is assist clients in maintaining the right paperwork and right records and advising clients on this use. Or it may be, in my experience, many of the very large and even medium-sized tax accounting firms in the country also have this experience, have one or two people that are the aviation tax gurus that can lead you through this. It is a mistake to let a client buy a business aircraft for the first time without making contact with one of those people and really sitting down and discussing those issues with the accountant. Because you have to go into this with your eyes wide open. Otherwise, no one likes surprises during tax season, and you can get some very quickly. We should also know, or your executive, the president of BIGCO, should also know that the personal use of the business aircraft has personal income tax consequences for those that fly on it. Personal use of an employer-provided aircraft is a fringe benefit. It's a taxable fringe benefit that is included in the employee's gross income. And the fringe benefit is taxable to the employee even if the employee wasn't on the flight. So if the president of the company decides he is going to send his college-age daughters and her 6 friends on spring break on the aircraft, the cost of that trip for each of those individuals is imputed to him because they're his guests on the aircraft. So that's something to take note as well. Valuation of the fringe benefit amount is either the fair market value or the SIFL rate, and SIFL is the standard industry fair level. Fair market value is not used tremendously frequently. That it would be the cost of a charter flight. So if you're going to use the fair market value number, it's important that you get a quote from your local Part 135 charter operator that says, this is what this flight Naples would cost, or to Vail, or wherever you're going, and then to impute that amount to the executive's income. The other way to do it is SIFL, and again, we could do a whole 30 to 40 minutes on SIFL and all its rules and exceptions, and there are many to them. So this is, again, a very 101 introduction. But SIFL rates are published every 6 months by the IRS and are modified by an aircraft multiple that depends on the size of the aircraft, what its maximum gross weight is. And there are different rates for control employees, roughly executives, and non-control employees. And there's also a terminal charge that changes every 6 months. It's also included on your general airline tickets that we pay when we fly the scheduled airlines. And it's a simple calculation, and I have one here for you just to look at. These are using today's current rates for a flight from Chicago to Naples, Florida, which is 1,145 statute miles on a light business jet. The first 500 miles are 24.9 cents a mile. The next 645 miles have a SIFL rate of 18.98 cents. Gives us a total of about 246, just under 247. The aircraft multiple for a light business jet that I used is 300. Now, there's one that's higher, and there are several that are lower, but this is a good business jet number. And when you multiply it by 300 and add the current 45.52 terminal charge, we get $786.28 as the SIFL rate per passenger. So if the executive traveled with his wife, it would be a little bit over $1,500. Now, remember that he doesn't pay $1,500 in taxes. And I guess let me back up and say the purpose of the SIFL rate is to approximate business class airfare for a control level employee. So, and it's not a perfect system, but $786 business class one way. It's a pretty good approximation of that flight, probably. But the employee only pays tax on that. So assuming, even a very aggressive, assuming, let's say, a 30% federal income tax bracket for the executive, they're not paying $786 in additional taxes. He's going to be paying, $240 in additional taxes. So he still probably comes out a lot ahead than going off and purchasing a business class ticket on United to make that flight. And he gets to make it directly to Naples without having to change planes anywhere, which, of course, is a price for the convenience. So, but executives don't always understand those rules, and they really, again, especially if it's someone buying their first jet, their first aircraft, they need to understand the personal income tax provisions. There are occasions, and it's fairly common, when an executive, the president, will call back and say, well, I want to use the jet, but I've either got partners or shareholders that aren't going to like it. Because this $786 number doesn't come close to reimbursing. The flight cost is going to cost the company a heck of a lot more than that to operate it. So the president comes and says, listen, the company, my shareholders or my partners, they're just not going to like the fact that I'm using the jet this way. And so I'm not going to use it very often, but when I do, I would like to reimburse the company for my use of the jet. Just what did it cost you with fuel? What did it cost you in landing costs and other variable costs? What did that flight cost? And let me write you a check for it. It'll still be cheaper than me going off to the charter operator to do it, because you're not going to try and make a profit off of me. But then the company doesn't lose any money, and it doesn't look like I'm abusing this privilege of having an aircraft. Well, generally, that's not allowed. We can't have compensation from an executive back to the company for the cost of operating the business jet. But there are ways around it, and perhaps the best way around it is what we call partial reimbursement through a time-sharing agreement. A time-sharing agreement allows a company to wet lease, and when we say wet lease, we mean an airplane with a crew, and allows for reimbursements of very limited costs. It's basically up to 200% of the fuel used on the flight, plus travel expenses, landing fees, hangar costs, etc. And it's possible for the executive to enter into this type of time-sharing agreement with the company, which would allow for partial reimbursement of the flight. Now, this is better than nothing, but of course it doesn't completely compensate the aircraft owner, the company, for the cost of the flight. But it does allow for partial reimbursement of the costs. This exception under the rules only applies to large and turbine-powered multi-engine aircraft. There are exceptions, though, for people who operate smaller aircraft if they're members of the National Business Aviation Association, and a special exception that's been granted by the FAA to those members. But there are steps that need to be taken to take advantage of these solutions. And a time-sharing agreement, frankly, is just one of the solutions. So again, if we're in a situation where we have an executive that wants to reimburse the company for the cost of its flights, it's really important, I think, to find someone either on the legal side or the accounting side that is very familiar with these options and can look at the situation and provide a solution. There generally is a solution to allow an executive to make that partial reimbursement to the company, but it can't be done simply by writing a check. That's not allowed. There's some steps that have to be taken first. There may even be, the FAA may even have opened the door. They have opened the door to allow for full reimbursement of the cost of flights. Now, for years, the FAA had issued an opinion actually the Charles Schwab company, that said that full reimbursement simply wasn't allowed. But in 2010, the FAA created an exception and said that there may be circumstances where full reimbursements of the cost of a business aviation flight are allowed for high-level employees whose position merits a high level of corporate interference into his or her travel plans. If the company has a need or can, reasonably project a need to immediately recall the employee at any time, if the company has such control over the employee's schedule that making advanced flights for vacations or advanced plans simply isn't practical or reasonable, and if the corporation takes very specific corporate steps and makes certain findings that is indeed the case, the FAA may allow full reimbursement of a flight. They have emphasized that this is a very limited exception and that not every company is going to fall into this. In fact, most companies will not. An exception, it's not the rule that the company chief executive officer will fall under this new exception. But it's there. So if we have a situation where an executive is interested in using the business jet and reimbursing the company because, frankly, it's the only way that he or she can get away, that oftentimes at the drop of a hat, the executive is recalled because of corporate emergencies, or if that every time the company goes away, there's a reasonable chance that could happen, it may be worth exploring whether or not under this new 2010 exception, we can have full reimbursements for high-level employees. But again, there's a process that has to be worked through on the corporate side. There's some investigation. There's some corporate governance activities that have to take place. And the FAA has to be notified of it, or at least there has to be a list that will be provided to the FAA upon request. So it's not something to rush into, but it may be worth some exploration. To be honest, I have very few clients that have chosen to go this way, but it is at least theoretically possible, and it should be on everybody's checklist. Final update to the scenario. After we've got this all settled, we've got a management agreement with a Part 135 operator. We know what's going to happen. BIGCO's president calls, and although we've been talking about this transaction now for 6 weeks or 6 months, he's got an aircraft broker that's found the airplane, and he's got to act fast. So after 6 months of discussing this transaction, everything's got to happen in the next 38 hours, he says. There's another buyer. It's a great deal, but if we don't do it now, the price is going to go up. The broker knows the seller, and trusts them, so there's no reason to expect the aircraft. And the broker has a standard contract that she's used with the seller before, so we can go ahead and get this done. And that's the final mistake, and that's not planning. And maybe this should be mistake number 1 because it's the overarching issue that I think we've talked about for the last hour. Business aircraft are expensive assets that operate in a highly regulated environment. There are many issues that have to be determined before you buy an airplane. And the biggest mistake you can do is to rush into it without having thought through all the issues that we've talked about today, plus the issues of actually going through the transaction of buying an aircraft. Cape Town registration, for instance. This would probably be mistake number 6 if we had an extra 20 minutes. But mistake number 6 would be not registering the aircraft pursuant to the Cape Town Treaty on mobile assets. That in the United States, aircraft that have at least 8 seats, including crew seats, not only need to be registered with the FAA in Oklahoma City, but also need to be registered on the International Registry, which is in Dublin, but really exists only on the internet, from what I can tell. Failure to register on the International Registry means that your interest in the aircraft is not perfected, and it is simply a first-to-file system. Even if someone else knows that you bought it, if they register first in a second transaction, they're the legal owner. A lot of brokers and a lot of salespeople will tell you, oh, no, you don't need to register on Cape Town. That's not true. If your aircraft is covered by the Cape Town Treaty, you need to register on Cape Town. That could be another webinar for another day. Sales and use tax issues, the disallowance issue, passive activity, all these things need to be considered. And it's not always easily or even, it's not possible to easily or cheaply undo the business structure operations after the fact. So planning is very, very important. And I can't tell you how often we sit around and it's just simply a theoretical idea of buying an airplane, and then all of a sudden we want to buy the aircraft, close on it, and set up a new corporate structure for it, all within 36 to 72 hours. And that's not smart, and it's not wise. So planning ahead is of the utmost importance. So we've hit 2 o'clock Central, and so that ends our time. So I'd like to thank everybody for attending. My contact information, I know Crystal said she was going to provide it later, but it's also on the last slide. I'd be glad to discuss any issues that we've talked about or that we didn't talk about with you later offline. That would be great. But we do have at least one question, I think, that's come in. And it relates to the flight department company. And the question is, it's actually a very good one, is a flight department company also an issue when an individual creates an LLC that owns the aircraft? And the answer is yes. That we see this a lot too. We have an individual that comes in, says, hey, I want to own the aircraft, and place it in a single-member LLC, to shield it, and then I'm just going to make capital contributions, that can cause a flight department company issue. It's usually one we can get around pretty easily with a lease back to the owner. And there may be reasons why we still want to go ahead and place the aircraft in that single entity LLC for tax purposes or to avoid use tax. But it's always an issue when we have a single-purpose LLC that exists simply to own and operate the aircraft. I don't think we have any other questions. So with that, again, I'll thank you once again for attending, and I hope everybody has a great rest of this May afternoon.